Good evening, viewers. Welcome to the Lifeline on Equa TV Africa. We are glad to be here today, and we thank you for being with us. Today, we will be discussing the issue of the Electoral Act, the amendment of the Electoral Act under the topic, the Electoral Act 2020, legal issues arising. But before we go into that, we'll first of all discuss the sacking of the Ebonyi State Governor, His Excellency Dave Umahi, who defected from the party, the People's Democratic Party, under which he won the mandate to be governor of Ebonyi State, and went over to the APC. The Supreme Court the Federal High Court yesterday sacked him from being governor for the reason of defection from the People's Democratic Party to the APC. We'll be discussing that, and with me in the studio is Barrister Godfrey Matthew. Welcome.
Good evening, viewers. My pleasure being here once more.
We are also expecting a legal practitioner in person of Polycarp Latau. He will hopefully be joining us in the course of the program. So we'll go into the discussions on the sack of the Ebonyi State Governor by Federal High Court for the reason of his defection from the People's Democratic Party, under whose platform and sponsorship he became the governor of Ebonyi State. He had defected from the PDP and went over to the APC, the ruling party. What are the legal issues surrounding this? So much has been said for and against this decision of the Supreme Court. So, Barrister Matthew, what is the issue about Mr. David Umahi, his defection and then the subsequent sack by the Federal High Court?
The legal issues surrounding Umahi's defection, as well as the judgment of the Federal High Court that sacked him as governor, stems from the constitutional provisions of his role as a duty to remain loyal to his party that brought him into power. However, we have to look at this through the critical eyes of the law to be objective in assessing the judgment. But before this, I would like to comment as a Nigerian lawyer who is a staunch member of Nigerian Bar Association that I am happy with the position taken by Nigerian Bar Association from our president Olumide Akpata, who has censured the comment made by Umahi, who after hearing of the judgment, he went and made some statements that are benign and denigrating of the status of judiciary. And we thought as lawyers it is our duty to promote the rule of law and to condemn his statement as judicial rascality. Now, having said that, I would like to delve into the main issues surrounding him. The court sacked Umahi and his deputy governor alongside with other 17 members of House of Assembly that have defected alongside with him from PDP to APC. Now, what are the legal issues there? The provision of the law states in section 68 sub 1 G of the Constitution and 109 G of the 1999 Constitution is talking about what happened whenever a member of a parliament defects from a party that sponsored him into power, and what are the consequences. The consequences is that when a member of a legislature departs from his original party that brought him into power and defect to another party, the law is that that person his seat can be declared vacant, especially when there is no fraction or division in the party. Now, we have to look at historical and legal antecedent that has followed that with respect to the office of the House of Assembly. Now, in the respect to the House of Assembly, in 2011, the office of Honorable Sunday Abegundiade of Ondo State faced the same position challenge. And now, in the respect of doing that, the court found out that he, Abegunde, left Labour Party and decamped to ACL. Now, when he defected to ACL, he went to court and challenged the power of the Ondo State House of Assembly, the Speaker, not to declare a seat vacant. The court held that, no, your seat can still be declared vacant, because even though there was a division among the Labour Party in Ondo State, that division is just within the state. So for a division to qualify for a member of House of Assembly to decamp or to defect to another party, that division must be what? National. That's why you see when PDP was having problem during Modu Sharif and late McCarthy's faction in PDP, some legislators deflected from PDP to APC. You can't challenge their mandate because the Constitution provides that the splintering or the division must be of a national reflection, not even within a state party. Now that justifies the doing of that. And if you look at it also, the question is that this judgment that Federal High Court gave, is the Federal High Court right? Yes, in my opinion, the Federal High Court is right with respect to the legislature, but not to the executive. And why is it not to the executive? The provision of executive, as when a person can cease to be a governor or a president, has been settled in plethora of cases. I will mention the cases. The provision that has to do with a party, member of a party defecting and losing his seat or losing his position only apply to the parliament. Because in the historical antecedent, we have the parliamentary system in 1963. So where defection clearly means that your seat will be declared vacant. Now, when we came to the 1979 Constitution, that position was not there. Then we come to the 1999 Constitution, we have it. It does not apply to the executive. Let me take you history lesson. In 1983, when the former governor of Borno State, Ibrahim Goni won this gubernatorial seat under the great Nigerian People's Party of Aminu Kano. Later on, he now decamped from GNPP to the, I think, NPN by then. And the members of GNPP now instituted an action against and say, no, he can't do that. FEDECO, okay? They say he can't do that. Now, having so FEDECO now that the court held that, no, he has a right as a member of the executive, that section under 1979 Constitution applies only to the parliament and not the executive. History learned some 20 years later, in the case of Abubakar versus Attorney General of the Federation, that is the present Atiku Abubakar, when he was in Obasanjo as vice president, he decamped from PDP to ACN. Now, the People Democratic Party, by then, instigated and said that let's institute an action against him, and the Attorney General of the Federation instituted an action to declare the seat of Atiku vacant. And the court held that no, the provision of section 109 and 138, 139, which deals with when the office or tenure of the president can be determined, does not include the executive. So a governor has a right to defect from one party to another as far as the present constitution is concerned. He has a right to defect from one party to another without any legal consequences. That's why you ask yourself, why is it that it was easy for Zamfara governor to decamp from APC to PDP? There's no legal hitches. Now, his deputy governor is saying that I am not following you, I will remain here. I have my right, and now they are contesting whether to impeach him. But you can see that based on this judicial precedent, FEDECO versus Goni, 1983, Abubakar versus AGF, 2007, the Supreme Court has settled it there that defection of a governor or vice president or president to another political party does not serve as one of the grounds upon which he can be disqualified. The grounds for the disqualification are spelled out in the Constitution, whether he has been adjudged to be insane, whether he cannot perform his offices, whether he adjudged to be lunatic or one. These are the conditions, but not when he decamped from one political party to another. So that is the jurisprudence underlining the justification or otherwise of a governor depending. Summary, a deputy governor or a governor can defect to another party without any legal consequences. Is his freedom of association. But a member of House of Assembly has a restriction under the present Constitution. He can't do that. So,
in this case now, we can conveniently say that the Constitution is biased against the legislative houses, because they are both Nigerians. They have been sponsored by political parties.
Yes.
Then in the case of a legislator, if you move from your political party that sponsored you to get that mandate to another party, you lose your seat. But in the case of a governor, you do not lose your seat. So it is different strokes for different folks.
It is different strokes for different folks. And I don't like to say that the Constitution is discriminatory. There are certain perquisites of office that the executive enjoy that legislatures don't. When you talk of immunity, executive enjoys immunity. Legislature don't enjoy immunity. When you talk of other issues, again, you can see that legislature appear to have more control of the party in terms of who decides what policy is formed in the party. The executive, at the aim of president and the governor, equally control them. You can say that the application there appears to favor the executive. Like I said the previous time here, I said one of the issues that we shall be looking at is that the immunity concept empowered the executive to even institute an action against another person while they are in office. A typical example is what I cited with the case of Donald Duke versus MTN, Globacom Communication 2007, where he sued them for defamation. And there is an objection that no, he's a governor. He cannot sue because of immunity. Immunity favors him there. But you look at it from that angle also. The danger there is that the executive also, they also enjoy the favor of the Constitution in that you cannot they can defect to a political party without any consequences. I think the spirit behind that was probably not to subject them to a lot of controversies during the subsistence of their office. If the lawmakers wanted them to be punished for that, they can equally insert in the Constitution to the effect that the same applies to them. So it's a call for general overhauling of the Constitution in such a way that we will reflect, let me put your language, equality before the law.
Okay. Yes. Now, as it is now, a court of competent jurisdiction has passed a verdict that Dave Umahi and his deputy are sacked. What is the legal implication? Dave Umahi is saying that is an illegal decision and all. What is the legal implication?
One of the orders of this judgment is that the name PDP should submit a person that will serve as a governor to INEC, and INEC should swear him in. And yesterday I learned that PDP have done that. One Igwe somebody and his deputy were appointed. Now, no matter how perverse, quote and unquote, no matter how perverse the judgment of a court and order of court is, it still remains an order of court until it is set aside. So before the time to appeal against this judgment, either, I don't know whether it is 14 or 30 days, whatever it is, if INEC should comply by swearing in these people as governors, Umahi has no seat in that place. The Speaker of the House of Assembly of Ebonyi, if he's among the decampees, I don't know. But if he's not among the decampees, he should declare the seat of those people that decamp vacant, and then election should be conducted there. But we can see one thing there. The outcome of this judgment has also put INEC on a hot seat, because INEC has to do with the issue of now setting a election for the offices that are declared vacant. Now, the office of Umahi now is that they have to swear in another governor. We are occasioned to have governors that are brought in by the judiciary. We have the case of Governor Hope Uzodinma. There he was brought in by the judiciary. We have the case of Amechi. It's a product of judicial intervention. Most of those people, so Diri was there. So this one should not be an exception to the case. Even for 14 days, let them come and enjoy the status of governor, so that even the Court of Appeal obtain the judgment. They also have the right to say that they are pursuing the judgment pending the outcome. But right up now, the right position of the law is that let him obey the order of the court. It will depend if INEC are able to implement the judgment on time. But INEC is also put in dilemma, because what they're thinking now, okay, if within 15 days, if we made these people governors for 3 days now, the judgment went and expeditiously. But I think INEC should follow the law. We want to strengthen our democracy ahead of 2023 election, so that people will know that there is no rascality any longer for the integrity of our electoral processes and for the independence, for the integrity of our institutions that project separation of power. That's what we want to do, the government want to do now. Their judgment should be what? Should be respected until set aside.
Yes. Yesterday, after this judgment, some lawyers came out to criticize the judgment and say all sorts of, may I say, unprintable words against the court that delivered this judgment. What do you have to say?
I think we are losing it there as lawyers. There is nothing wrong with you criticizing or analyzing the judgment of a court. But the problem where we are having it is that when we come to media house like this, we appear to create an impression to the media that we know it all better than the judges. And it is quite unfortunate on the side of the judges. They don't have the right by their professional ethics to come to radio station and speak like this. They are always in cul-de-sac state of mind that they are not allowed to come up publicly to defend their judgment. So we as lawyers also have to speak for them. That's why I'm happy with what our NBA president Olumide Akpata has done by calling out and censuring the comment of Umahi, because Umahi was speaking with legal authorities that emanates from the branch of law. He was speaking with the voice of Esau, with the voice of Jacob, but with the skin of Esau. Because those what he was saying, he is not in the intellectual capacity to understand those wordings, except they have been put by his lawyers. And so these are some of the things we are censuring. A lawyer is entitled to criticize the judgment of a court with decency and decorum in his choice of word, in the application of his diction, and in his reasoning. You don't personalize it. You don't go and make it as if the judge doesn't know what to do. Our judiciary, our profession has taught us the sanctity of legal profession, that no matter how perverse a judgment is, it must always and always remain a valid judgment until set aside. So even if you're having grievances with that judgment, you can go out professionally, criticize it like we are doing here. We are looking at the legal issues. The way we are talking here, I don't think I stand to be corrected by our viewers if I sound any way denigrating before the court. But I say that with respect to the sacking of the House of Assembly, the court is justified. But with respect to the sacking of Dave Umahi and his deputy governor, the court, based on judicial precedent, the court is not right to my conviction.
Yes. Now, should a lawyer criticize the judgment of a court on the media or on appeal? Which is the right way to go?
Professionally, a lawyer involved in the case is not allowed to come to media house. If I'm the lawyer to Umahi, I wouldn't honor this invitation of being here. I wouldn't honor, because it would bring a conflict of interest. What I will do is to prepare for my appeal upstairs, and now to see how can the judgment against me survive the scrutiny of the eagle eye appraisal of the appellate court. Can it survive the appraisal of the Court of Appeal? Can it survive the appraisal of Supreme Court? If it does, then I know that yes, judgment has been done, or a judicial precedent is about to be set. So these are issues. But as a lawyer that is involved in the matter, you can't come. It's like self-medication when you are trying to treat yourself. So it will bring about conflict of interest. That is why the RPC, Rule of Professional Conduct, equally enjoin us to be sensitive of such issues. That even when we come to media houses, cases that we are involved, we should exercise some discretion in such a way as not to exhibit bias or any other thing.
So in the appeal, you can say the court erred in law and go ahead to say how
you can particularize, deviated from the judicial precedent. The court erred in law. The grounds, you itemize them, you particularize them. The learned trial judge erred in law when he held that Umuahi and his deputy up to what? To vacate their offices. He did not avert his mind to the position of the law in so judicial precedent. You'll find it there. That is why you see that lawyers that are no lawyer that involved in a case, even if he got a judgment, it will be difficult for him to come to the studio to rationalize. But those of us that are not party, we have the objective mind to assess it from there. And I believe that the reason is that since it's a federal high court, I believe the judgment should have been through originating summons, which is which could be a process through interpretation of statutes or affidavit evidence deposition. Now, they have also known they are setting evidence whether the court averted his mind or he did not. They will be able to do that. Whether they prove any document or any authority to that effect, that the court did not avert its man to apprise or to evaluate, all this will be addressed at the Court of Appeal. But as of now, the position of the law still remains the law, that David Umahi is no longer the governor of Ebonyi State until that judgment is set aside.
What if he files an appeal?
Filing of appeal does not prevent the enforcement of judgment.
Okay.
It does not prevent the enforcement of judgment. That is why the court gives you a day that the court in some orders will make consequential orders, will make relief that you granted, that this and this should be enforced within those days. That's why the court went ahead to give a consequential order and give a declaratory that INEC should swear in this guy before, how many days? I think within 14 days. So he has a latitude now also to what? To appeal within that time. So by appealing within that time, it means that he can also what? Contain the judgment. He can give that guy, if the Court of Appeal set aside the judgment, the Court of Appeal will say that, oh, this guy is a governor for 3 days. This guy was one time a governor for 40 days. Like some people will jokingly say that they want to be a president, they want to be a president of an association, they want to be a president of a group just for 1 day. So we may likely see that reflected, maybe whether a governor in Ebonyi for 1 day or governor in Ebonyi for 2 days. Then what I think we have to look at it also, where this judgment, will it affect the computation of time regarding the running of the government of Umahi as his second tenure or his first tenure? These are some of the anticipatory legal issues and political issues that should come into mind. Assuming now that he went to the Court of Appeal and lost, and then he went to Supreme Court and lost, now you now ask yourself now, does it mean that, okay, this guy now, the calendar of Ebonyi State is now shifted because Ebonyi will not participate in the 2023 election? You know, we have some states that have peculiar election calendar, like Ogun State, Anambra, and most of these Ekiti, Edo, most of them are product of this what? Bad leadership, you know, and that come into governorship tussle. We are having Edo now too, as an addition. So you find out that we are going to have some of them. If we don't sanitize the system, we may come to a particular year or maybe a month, where INEC will be conducting election every month for those offices that were truncated and not going concurrently with the general election. So these are some of the challenges that we should be expecting.
Yes, now, is there anything Umahi can do to place the execution of the judgment on hold?
The execution of the judgment on hold, I think, in my own personal opinion, the court clearly spells out what to do, to be done. Yes. So when you want to place an execution, remember, it was not only the court give directives that directing INEC, that let INEC enforce the judgment. So where can you now go and obtain an order to set aside the judgment of a court? An order that is meant to challenge the judgment of a court on its own, it was an illegality. So you now find out that it will be difficult, because if they file, the order will oppose. They say that judgment is seeking to challenge the orders of the court. So it will be another legal battle. The only thing that I believe is that they may decide to deploy that tax and there will be a problem with enforcement. If the executive at the presidency should respect our democracy, or at the APC should not tamper with the judgment of this court. Let it run its course. Umahi has a way of expressing his grievances. Let him go to the Court of Appeal and see what lies ahead of him there.
Yes, my question is, if he goes to the Court of Appeal, for instance, and he files an appeal in the Court of Appeal, can he file an application for stay of execution pending the determination?
That was what I said. A motion for stay of execution, he can file, but remember, a motion for stay of execution can be challenged.
Yes.
Depending on the content of the judgment.
Yes.
Like this one now, if Adibin say that it's a mere declaration, that they say, okay, he's no longer the governor. There was no time, it's a declaration. But there's a consequential order that a particular agency should go in and swear in another person as a governor. Why do you want to stay of execution of that judgment? You are filing the stay of execution not in the Court of Appeal only. I think you are filing equally at the lower court. So he will equally oppose that a judgment, a motion that seeks to set aside the order of that court will be invalid. But if he files in the Court of Appeal simultaneously without any opposition, if the Court of Appeal sell out the judgment, that could be true. But if the process still is the one filing it, serving the, the stay of execution can be enforced by the judge, by the bailiff of what? of the Federal High Court.
Yes.
So the issue now is that it is the same court that he will now equally apply to. So how can the court turn against its own order? The only exception is if he files simultaneously to Court of Appeal and it is not challenged as abuse of court process, then it is given expeditory hearing. I think within 2 days or 3 days, if the Court of Appeal says that the judgment could be stayed, then that means the law is favors him.
Well, yes, this is what we are looking at. I mean, the question is, when a judgment is appealed against, the appeal is said to have been filed.
Yes.
And then after the appeal is filed, processes could be filed at the trial court for, say, stay of execution.
Yes.
But when the appeal is entered,
yes,
that is where
the Court of Appeal now assumes
the record. Yes, the record
is transmitted.
The record of proceedings, in other words, called record of appeal, is transmitted from the trial court to the appellate court.
Yes.
When it gets to the appellate court, the appeal is said to be entered.
Yes.
It is at that time that the appellate court will assume jurisdiction.
Yes.
Now, in this case, can the judgment debtor now, Umahi and his deputy, after filing an appeal, can they also file a motion for stay of execution pending the hearing and determination of that appeal?
If they are able to do that within time, like I said, they must remember, before, one of the conditions for stay of execution is that you must have the valid notice of appeal, must have been filed. Yes. So if they are able to do this and get the record transmitted, they can file it there and equally file it at the Court of Appeal. The problem there is that the motion now that they will be filed for the stay of execution, it is the trial court that has jurisdiction on that.
Yes.
So it can determine whether to grant it or not to grant it. But I know, as a matter of practice, the party who is a judgment creditor will vehemently oppose that because there's already a consequential order. Do this in my favor. So by the time they will be spending their energy fighting on this, time will be going on. And if they are lucky to get it at the Court of Appeal, the case management in terms of delay tactics will favor them. If the Court of Appeal rule maybe within 1 week or 2 weeks and set aside that judgment, they can still come back. But if not, if the trial court is willing to overrule them again with the respect of stay of execution, remember they have to do what? 2 appeals now. And you can still give an order for them. That's why I'm saying that the best thing in my own thinking is that let them, if they believe in the rule of law, let them give these PDP guys 2, 3 or 2 1 week governor. Let him governor.
But do you see this as an opportunity for the ruling APC to make sure the judgment is enforced, to show that they are actually obeying the rule of law?
I think the present dispensation of APC has not shown us that it is that committed to enforcement of rule of law. I think the governing style of the president and the antecedent of this government has clearly shown that they are less friendly towards the enforcement of rule of law. I'm saying
but
this.
Remember, in Bayelsa, when the APC governor was sacked,
yes,
in fact, the APC chairman, national chairman, came out to say nobody can remove the governor. But eventually, the APC government made sure that the judgment was enforced, and that is why we have Jittery as governor of Bayelsa now.
Governor.
Do you think they will do the same in...
Let me tell you, which party is Jittery from? Is Jittery from PDP?
It's PDP.
Now, if they have done that, we can equally say that let's obey it, let's expect them to do it here. We can't override them. If they've allowed the one in Bayelsa to take place, I don't know, but I believe that Saye will be somebody that will inform them the right position of the law. Like he said today, he come out and said that this judgment should be allowed. If there's one thing I will thank this regime is the presence of people like Saye. He has not compromised, despite his apparent what appears to be by others as controversial nature. He always tells PDP the truth, and I don't know, I wonder how he does that. Yes, APC the truth, and I wonder how he does that. Because in this judgment, he clearly said that let the judgment remain. It's still a precedent. Yes. While others like Ezokome and Idris Okutepa, by the different view, they say that let it remain like this. So if they can heed to his advice. Let them prove Nigerians that they respect the rule of law when it comes to enforcement of judgment.
Okutepa, not Idris. Jibril.
Sorry, Jibril Okutepa. Like calling Idris.
Yes, viewers will be going on a short break. When we return, we'll go back to the Electoral Act 2022, legal issues arising. Yes, it is still the lifeline on Equa TV Africa, and we have discussed the sacking of the governor of Ebonyi State and the 17 House of Assembly members by the Federal High Court yesterday and the legal issues around it. The phone lines will be opened for questions, comments, or you can call to make your comments and ask questions. The phone lines will be on the screen and you are free to do that. Yes, we are back. We are now discussing the Electoral Act 2020, legal issues arising. Yeah, Barrister Matthew.
Yes.
We discussed the legal issues around the Electoral Act 2020 just last Wednesday. And afterwards, the President wrote a letter to the National Assembly requesting the amendment of Section 84, subsection 12 of that Act, which prohibits the participation of political appointees in primaries of political parties. We had discussed this section last Wednesday, and today there is a letter to the National Assembly to amend this provision of the Electoral Act. What do you have to say about the requests and the legal implication of that request?
As of the request, I would like to respond from the fact that changes come with a lot of give and take. Some of the give will favor us, some of the take will not favor us. Some of the give will not favor us, some of the take will favor us. In this instance, you can see the transaction between the legislature and the executive. Some of the give of this amendment favor the legislature, some did not favor the executive. Some favor the executive, some did not favor the legislature. So there must be a compromise in overwhelming national interest. Legislature are now saying that, okay, with respect to this, we are now agreeing that in case of event of any death, and the person that is appointed to the executive governor office of the executive governor, if he dies, we party can now nominate another person. That reflects party interest. Legislators are now saying that we now agree to the issue of accreditation of voters, transmission of electronic results. That satisfies general election, which the legislators see it as one of their main contribution to Nigeria. Nine assemblies see it as their main contribution to Nigeria's democracy. Yes. But the executive, on the other hand, are not comfortable with the provision of Section 84 sub 12 that talks about the appointees, okay, of the governor or the president resigning before contesting an election. And we ask ourselves, what is wrong with that? I remember we say that it is good because it is meant to avoid conflict of interest. That is why you will see that even in some schedules of the Constitution, the position for the appointment is done in such a way that it doesn't affect conflict of interest. Now, factually, it is garnered that the legislature are also observed that the guys in the executive control a lot of influence, exert a lot of influence with respect to the political machinations. And they are now saying that no, if we allow these guys to be in the executive as well as influence the flow of our political affairs, it will equally affect us. You can see how it affected Zamfara. The desire of the governor, the imposed primary, whereby the governor conducted a primary without the party chairman, clearly shows the power that executive can interfere with the electoral processes. So they are saying that no, if you want to do anything like that, remember when you conducted that primaries in Zamfara, he was aspiring to come forward senator. So you can now see some of these things. As I saying that, no, let there be dichotomy. If you are there, resign. Don't still be in the executive and then be in the legislature, vying for the legislature at the same time, because it will affect conflict of interest. You will not be unbiased. You will not be disinterested. You will not be fair and just to other people. So these are some of the issues that are saying that let it be that. Now, the president now haven't seen that has the right to, and people are asking, who are the people in the presidency that are interested in having that particular session and all? Political sociologists were able to tell us that there are certain people that in the appointment of the president as ministers, commissioners, that they want them to be reflected, okay, in the next administration as governors, to be reflected as leaders in the next administration as governors, as governors and other political office holders like senators. So this is what they are saying. But like I said the other time, this thing equally applies to what? To appointees. So these are some of the issues. And I don't know why is that a major challenge for the president.
Or concern.
Concern to the president. The president has a power under our constitution. All appointees under the president, in labor law, we call them employers at the pleasure of the master.
Yeah.
He can sack them anytime he wants. He can do away with them. Let them go and contest. Why are they interested in amending the electoral act? He has that administrative power that is endorsed by common law and acknowledged by our judicial president. Let me give you a typical example. You remember when the former Minister of Finance, this lady Adeosun, was sacked because they say she doesn't have NYC. NYC is not a condition for appointment. NYC is only condition for employment. There's a difference between employment and appointment. Why can't she challenge God? Have you ever seen any minister or a commissioner that ever challenged a governor for removing him? No. Let Buhari exercise that power. The Electoral Act does not need to have it. Let's leave the Electoral Act. In fact, the Electoral Act can even help President Buhari in performing his administrative duty, because he has the right to sack any one of them, to end his to terminate his appointment, and let him go and engage in politics. If they want to go into politics, let them meet him, let him discharge him. But why is it that he wants them to be in the office and then still be influencing political affairs? That is unfair.
Well, can this be seen as a way of having undue advantage? Because if a school teacher is required, because he's a public officer, he's required to resign his employment as a school teacher to go and contest election. I guess that is so that he will not use his position to get undue advantage over others.
Yes.
So if a school teacher is required to resign, why not a public appointee like a minister or a commissioner of a state? Why not these ones? When you make a teacher to resign, then a political appointee as high as a minister stays there and continues to work and use his public office to influence his position against the other people who are not. So is this not giving undue advantage to other people?
In fact, let me add to your comment that it's not only giving undue advantage, it's one of the instances of the discriminatory practice, which is prohibited by Section 42 of the Constitution. When you allow an employee to resign before contesting, why are you now kicking against an appointee who is a temporary office holder? And I'm saying this electoral act equally enforces Buhari's and Lalong or other governors' responsibility to relieve their political appointees before conducting election. Because they can appoint them today, say they are done with them tomorrow. These are not enforceable because they are employees at the pleasure of the master. So why is it difficult for me? The main person that is employed can comply with the provision by resigning from civil service or public service before contesting an election. Then somebody that I employ temporarily by appointment, I am finding it a big hurdle to release him. The law is even helping me. I have the power to do so. And that's why some people are saying that the president is not properly guided or has been misguided or malguided in order to protect certain interests. Because if you are advising the president, you say, no, president, this law is even empowering your administrative power that you can relieve an appointee that is aspiring for a political office. You can relieve a political person, any person in your cabinet that wants to go for a political position. That is what the Electoral Act is saying. It is consolidating his power. It is not against his power, and it is not discriminatory. Because if you are now saying that appointee is discriminatory towards the appointees, okay, what about the employer? So it also means that a permanent secretary can contest for an office and then still retain his civil service. A professor in the university can contest for president of Nigeria while he's still a professor. A rector of a polytechnic or a provost of a college can equally contest without resigning as president. That's what it implies. These are people that are statutorily covered. Appointment of special staff advisors and other members of the other appointees are statutorily spelled out in the Constitution. So what is a big hurdle? Since you can terminate their appointment without any hurdles, the law is saying that this is complementing your effort, especially if they want to contest for office. Release them. Why are you finding it irreconcilable to agree with this term? It means that the president might not have understood the import of this amendment as well as his constitutional power, or maybe something beyond our apprehension is going on that we don't know.
Well, by administrative practice, we have seen situations where chief executives give advisory to their appointees, say anyone who is interested in a political office should resign. I think last year, the governor of Benue State gave a deadline and said, yes, those who are desirous of going to contest for political offices should resign by 1st of October 2021. And a good number of persons resigned, including his commissioner for education and his chief of staff. They all resigned so as to go and contest.
Good.
So if they have, without a law, been issuing out this advisory or directive, why is it that suddenly they are now getting jittery when the law now provides legal backing for what they have been doing administratively? Will it be right to say there are some cabal, like you mentioned earlier, who are in the appointment of the president that are desirous of filling some elective positions come 2023, and so they want to hold those offices while they are vying for, hold those appointed offices while they are vying for elective offices. That is why they have written this letter. Can that be correct?
Every regime normally have its staunch policymakers that are always at the door of the corridors of power. They are always there telling the presidency what to do. During Yaradua, we have Ondoka, who almost misguided the president, misguided Nigerian, to an extent that when the president died, Nigerians were struggling about his incapacitation. We equally have it during this regime. A lot of the issues that are coming, when it comes to legal issues, and the president or the governor is not properly guided, there are two people that are the custodian of law. The Attorney General of the state, the Attorney General of the Federation. In respect to this case, Alami, Honorable Attorney General of Federation, Abubakar Malami, every political, legal blunder that is made by President Buhari, nobody can blame this Permanent Secretary of Solicitor General or Permanent Secretary of Ministry of Justice. The blame must fall on Malami, who is the AGF. And that's why we are saying that the president has not been guided well. Because if he understands the import of this, he wouldn't do it. Where the AGF and his team fail to guide him properly, it then creates an impression that they are interested in looking at otherwise or the benefit of the nullification of this section. This afternoon, it passed second reading, it fell. Because Nigerians have come to realize that we have to make the system work. Nobody is benefiting from the failure of this system. Politically, economically, socially, culturally, the system is failing. Politically, you can see how disoriented we are. People don't know the import of this judgment that Umahi is bringing to us. A time is coming, I'm telling you, if we don't take care, we will be conducting election in January, February, March, before a general election. Because we don't respect the sanctity of the political system. A time is coming socially, we have seen it here. You can see how socially divided Nigerians are. You can see how social economic life in Nigeria has reached to a state of comatose. People no longer see life with meaning. You can see the social etiquette of humanity is leaving us. We used to hear about ritual, killings, and most of this in as hearsays, or maybe a fantasy tale, or maybe something you see from the movies. We are seeing them living life here with us. And it all boils down to what? It has some semblance of good government. We see elder statesmen in political situations that we once look up to as model. They will come to power and start behaving in such against the ethics they taught you while you were a student, against the ethic they preached to you while you were in church. You see them deviating. Culturally, we don't have the integrity that our Nigerians of the 70s, of the 80s, of the 80s will tell you that this is a leader. He abides by his word. We used to cite Buhari as an example. Let others have contrary opinion come to say. Buhari is an anti-corrupt crusader, is an upright man full of integrity. But I can tell you categorically in a scholastic passion that Buhari's corruption index in Nigeria is the greatest compared to any president we ever have. This is a man that was adjudged to be what? Mr. Integrity. But the integrity index, corruption perception index of Nigeria raised woefully under him. Talk about World Justice Project. Nigeria is everything you can talk about globally. Is it economic, inflation? I don't need to say. So these are the things that people are saying that we want the system to work. And it is believed in Nigeria that the Marxist theory of political economy influencing the culture, the society in all facets is Nigeria is address the polity. Once you address the polity of Nigeria, the economy will be affected positively. The social life will be affected positively. Even the religion will be affected positively because it's leadership that is problem. And I remember Chinua Achebe of blessed memory. He said in his book, The Trouble with Nigeria, that the trouble with Nigeria is squarely the problem of leadership. There's nothing wrong with Nigerian climate. There's nothing wrong with Nigerian environment. But it is the failure of leaders to take up to personal hallmark of personal responsibility, which is the ideal of leadership. Tell me, when Buhari came into power, 6 months Nigeria were waiting for composition of ministers. People were guessing, and let's see who will believe. We are expecting that we will see people that we have never known their name. Of a sudden, we saw people that are recycling. And we saw some people that we know the antecedent coming before National Assembly to tell National Assembly that they have never been corrupt in their life. We see people that will come with their wives, and all they will ask is that, will you be surprised if this National Assembly asks you to take a bow and leave? And we take that for granted. Appointment came, sensitive position were given to particular people of religion and tribe. And Nigerians are saying that he's Mr. Integrity. We are looking there. People have been killed. Have been killed. He select which one to commiserate with and which one not to commiserate with. He select which national issues he's aware and which one he's not aware. And then Nigerians are saying that it's Mr. Integrity. We can do this here. It's about living. But with the signing of this electoral act, we have a lot to do to see how we can address these issues. If we sanitize the politics, hopes are green that maybe other facets of the life and equality will be reflected.
So do you see the National Assembly amending or yielding to his request to amend Section 84, subsection 12?
As I'm talking to you before coming this afternoon, the second reading has passed. National Assembly refused. They refused because the beef now is not only between him. There's a vendetta between the executive and the legislature. Remember, Malami once commented that the parliament don't know what they were doing. They usually have this fracas. I remember during Labaran Maku, there was a time he made similar statement that Nigerian senators and House of Assembly, they don't know what they are doing. David Mark has to call him and say, you are talking loud. He say, you are talking loud. Labaran Maku has to keep quiet because there's a way an elder coughs without you knowing what he wants to say. You already decipher what he will say, and so you have to behave. So when David Mark says you are talking loud, he has to listen. This time around, Malami came and said that the House of Assembly don't know what they are doing. And that's National Assembly. They don't know what they are doing. So now is what they are telling him, that they know what they are doing. And you can see now, he has written the letter, so they are thinking. Others always have it that he is interested, Malami may be interested in political position come 2023, or I have a governor of a state. I don't know that, but this is what the National Assembly is doing. Today, they have turned down that letter and they said that section remains subsisting in the second reading.
What are your final words to Nigerians? My
final words to Nigerians is that the Electoral Act, first I want to comment on Umahi. Let's accept the judgment of court in whatever manner it comes. As politicians, we are models. We should not denigrate the judge, or we should not denigrate the institution of judiciary. It has its faults. I think it is remarked that judges are not that the judges are infallible. They are final not because they are infallible. They are infallible because they are what? Final. So this is it. So let them bear with him. With respect to the Electoral Act, we welcome the development. Nigerians should also try and imbibe the political ethics of tolerance and also adjustment to social changes.
Yeah, before we leave, there's a comment from Polycarp Johanna Datau, who was supposed to be with us. He couldn't make it, but he sent a comment. He said, great discourse, guys. Blessings. Thank you, Polycarp. And let me say that for us as Nigerians, for us to move forward, there is something we must do. The rule of law. We must respect the sanctity and integrity of the court. Suffice it to say that it is very, very wrong for anybody to come out and challenge and denigrate the judgment of a court and the judge. So long as that judgment has been made, rightly or wrongly, the judgment is subsisting and it has become an order that must be obeyed. It is only then that society will move on. If the judgment is wrong, in case of the Federal High Court, there are the three wise men at the Court of Appeal that will look at it and say the trial judge was in error. If, on the other hand, he fails there, they will finally head to the Supreme Court that is final and infallible. So, well, the Supreme Court is not God, so it is not infallible because it doesn't make mistakes like God, but it is infallible because it is final. So once it has delivered a judgment, that becomes final. You can only appeal to God from there. Have a lovely evening and keep a date with us next week. Thank you for staying with us and have a blessed evening.